So, family law is a large umbrella term that encompasses adoptions, it encompasses relative custody, it'll encompass divorce, paternity cases. Generally speaking, someone is going to come see me for a family law issue that's more often than not a divorce. In a divorce, there are different types. You might have heard the word uncontested, you might have heard the word even contested, rather. Each family is different. Family law is not black or white, it's entirely gray. Again, I believe that makes it probably the most difficult area of practice because as attorneys, we have to look at not only what the law provides, but each family is entirely different. We continually tell clients that your case is not going to be the same as perhaps your friend's case. Just because something happened in their divorce does not mean it's going to happen in your divorce. So in a dissolution of marriage, when I have a client interview, not only do I get the general background from that client, the who, what, when, where, why, I then have to talk to them about their children and get every iota of information about their kids in that consultation form so that I have that information to know how to gauge a distribution of the child-related issues in a case. And there is a method to the madness that we do in divorce. There's an order in which we go, whether it is in settling a case or at a trial. And the acronym is PEACE, P-E-A-C-E. So P stands for parenting plan. It's the first part that we do in a dissolution case because we have to decide what sort of parenting plan and relationship is proper for both parties and the children moving forward. E stands for equitable distribution. We have to divide your stuff. Everything that's been accumulated during the marriage, no matter the name that it's held in, no matter how it's titled, if it was acquired during the marriage through marital assets, then we have to take that into consideration and award that asset to somebody or divide it up in some mechanism. That includes retirement accounts, that includes military pensions, that includes a home even. Then we look at A. A is alimony. Money is the root of all evil, they say, and alimony is essentially a four-letter word when it comes to a family law case. But alimony is not necessarily just based off of incomes alone. It's not necessarily just because one party makes more than the other. Alimony stands, the position or purpose of alimony, rather, is to support someone in the lifestyle that they were accustomed to during the marriage. Of course, the party having to pay alimony must be able to afford to pay that. The recipient spouse, the one that's asking for alimony, must also have a need for that alimony. So again, it's not a black and white determination for alimony. Then we look at child support, C for child support, because everything else that we've done in the case, child support is contingent on all of that. Child support's not a number that parties can agree on or just pick out of a hat. It is a complex formula that the Florida legislature came up with, and most firms in town, as well as the courthouse, we all use the same computer program that will calculate child support. It takes into account your gross incomes, it will take into account your applicable deductions for federal taxes, if you are working out of state, even those out-of-state state taxes. It will take into account who's paying for health insurance, not only for yourself, but for the children, as well as child care expenses and the overnight structure. How many nights does Party A have out of 365 days of the year, and how many overnights does Party B have out of 365 days? All of that will compute a child support number. And one of the first questions I get in any sort of consultation is, what am I going to pay as far as child support, or how much will I expect in child support? And I don't know until I get into the weeds of the case and compute all of those values and place them into that computer program. The very last part of a dissolution of marriage is E, for everything else. That could be a party requesting their former name back. That could be a party requesting attorney's fees from the other. Perhaps there's even a domestic violence case that we have to take into consideration, or even some sort of relocation type issue might come up. Lastly, there might even be mediation fees that one party wants the other to pay. All of that is considered at the very end. So we follow that particular order, whether we're doing a settlement negotiation or we're doing that at a trial.